And you're very welcome back. Now, the ongoing legal aid dispute was evident today when a judge described as disgraceful the fact that a man accused of murder did not have access to legal representation while in Garda custody. Meanwhile, the Justice Minister, Jim O'Callaghan, is not for turning with the plan for a flat fee for legal aid services. James and Matt are still with us. We're also joined by Legal and Public Affairs Manager at the Irish Penal Reform Trust, Niamh McCormack. James Geoghegan, I'll start with you. The government was warned that changes, the kind of changes that Jim O'Callaghan was proposing, would lead to a decline in the quality of representation. This has happened disastrously. So you're being called out by a judge today in relation to this.
Well, I think it's actually worse than what was warned. I mean, because in the long term, they're warning about a decline in representation. But what's happening right now is that solicitors are withdrawing their services.
Yeah.
And, you know, what the judge said, I mean, probably not great for members of the Oireachtas to be commenting on judges' utterances. But I mean, ultimately...
Well, I think you have to respond.
Yeah, no, I mean, I think, no, and I will. I mean, I think ultimately, clearly, the court is dissatisfied that solicitors are withdrawing their services to represent people, so justice can't actually literally be done. The Gardaí presumably are in a similar situation where they can't get solicitors to come into custody and to represent people that they're interviewing for alleged crimes. And this is happening in real time. So there just has to be a level of engagement that I think it's unfortunate that we've arrived at this situation
now. Why change
the
system in the first place?
Well, I think the justification from the Minister for changing the system was a report that was carried out by the Department of Justice.
That kind of sounds, if you don't mind saying so, like you don't really believe yourself. The justification of the Minister was...
Well, I can only, I'm not the Minister, so I can only say what he has explained the rationale for his decision. And the rationale for the decision, as I understand him to have made, is about the disparities between efficiencies, essentially, between, non-legal aid cases versus legal aid cases, the level of adjournments in those cases.
The suggestion was that the solicitors were purposely gaming the system. They were drawing out these cases. There was adjournments being sought in order to maximise their fees. The Minister has produced zero evidence for that.
Yeah, and can I just say, I actually do think that's a really unfair characterisation of a legal profession that, by and large,
well, that's not my characterisation.
The public trust. And I'm just saying that is an unfair characterisation. In evidence that they produced in this report, there were examples of where there was bad faith taking place amongst certain actors, certain solicitors in respect of the system. And those examples were given to justify some of the decisions that have been made about having a flat fee for your viewers. Previously, solicitors were paid every time they appeared in court on an adjournment basis. And
so now instead we're going to have rush justice, or maybe no justice, no legal.
So what the Minister then... What the Minister then communicated was that he was moving to a flat fee. I do think it's unfortunate that when he increased the flat fee, so it was at a certain level was the first offer, then the flat fee went up. Yeah. There was a fairly narrow period of communication between when the representatives of the solicitors, which is the Law Society, were communicated about this and when the flat fee came into being. And now we have this situation of hostility.
Do you think there should have been more consultation?
I think there's a level of engagement here that clearly hasn't been sufficient.
So should the Minister have consulted wider? Is that further?
Well, I think let's deal with the here and now. I think there needs to be more engagement right now because it's not conceivable that this will continue through the summer and into September.
Okay, Matt Carty.
Yeah, the Minister should suspend the new scheme and actually engage in constructive dialogue, which he hasn't to date. He's been asked to do that by the Oireachtas Justice Committee, and anybody looking at the consequences in the court, which unfortunately were entirely predictable, would see that this has been mishandled. So just to recall, what the Minister has essentially said is there are too many adjournments within the court system. I think most people would have a bit of sympathy for that. It takes far too long
for
cases.
Who's making the adjournments?
Well, that's the question. None of us know. And what he has said is, using very strong language, he has accused solicitors of engaging in unethical practices in relation to adjournments. But what he hasn't said is that it's actually judges that have to approve any adjournment, and it's his department that actually paid the bill. And what he has proposed to a flat rate payment, in my view, could be equally, if not more so, open to abuse, and certainly from a public expenditure point of view, because he is now going to be giving a flat rate payment to solicitors of over €500. And the same will be the case if somebody is in front of a district court judge for 15 minutes, maybe dealing with multiple cases on a Monday morning. They will get €500 each, whereas a solicitor who might be dealing with a very complex case that could go for several months would be getting the same payment. And that is the reason why solicitors have threatened to withdraw from the scheme, and it appears that they're following through on that, which is with very dangerous potential consequences.
Niamh McCormack, what's your take on this?
Well, I suppose the Irish Penal Reform Trust is concerned about the access to justice issues, of course, but just on that point around adjournments and whose decision it is to adjourn a matter, it's the judge's decision on whether a matter is adjourned, and it's the judge to decide whether it's...
you could say, well, you can apply for an adjournment.
You can, of course, but it's for the judge to decide whether it's appropriate or not. I'm not sure it's...
I suppose it would be naive to believe that adjournments are never given, and there's never any cases of solicitors looking to push the thing out a little bit.
Well, if there are concerns about that being an issue, then that should be raised as a disciplinary matter against those solicitors to the Law Society and to their regulatory body. You can't make policy based on accusations of malpractice of a handful of solicitors. That's not acceptable, particularly given how catastrophic this can be for people who need legal aid in order to be represented.
Okay. James Gagan, with the flat fee now, I think it's €520 as opposed to, I think it was 239 for the first appearance, and then the guts of €60 for the rest. I mean, is there a danger that solicitors are going to be under pressure to actually, let's deal with this case as quickly as we can. Let's not worry about the evidence. Let's not worry about the psychological report. Let's not worry about doing the legwork. That some solicitors might say, I'm just going to get this sorted. Let's get the guy to plead guilty, because that'll sort it all out in one go and I'll get my fee.
No, I really genuinely don't think that is a risk, because I trust... I don't think it's a risk, because by and large, we're very fortunate in the legal system that we have in terms of people's faith and trust in it. I mean, I think...
look, there's brilliant solicitors, but don't tell me there's not some solicitors out there who are going to say, we'll get this done quick.
I was never a criminal practitioner. I practiced in the civil courts for over 10 years. And I mean, what you're referring to there is basically that the solicitor would act against the interests of their client, even when liberty was, the risk of liberty of their client was at risk. And I really don't see us arriving at that outcome. I don't believe that's what our system is. I don't believe that...
Do you think there's any solicitors out there who would try and move things quicker because they're getting one flat fee, and if you can deal with it in one go, you get that flat fee straight?
I have seen no evidence of clients being represented in criminal courts where the solicitor or the barrister hasn't acted in the best interest of that client. Obviously, there are cases of malpractice, alluded to earlier, and they're dealt with through the proper disciplinary tribunals. But in terms of the figures and the costs, what's going on right now is that there's clearly an impasse between those who practice in criminal solicitor firms.
But there's a contradiction between what you're saying, what the minister's saying. The minister's saying the system is being gamed at the moment. That's effectively what he's saying. You're saying just nobody's gamed. Nobody would ever game the system. Nobody in the noble profession that is the law would game the system.
Yeah, I did hear the minister before the committee and elsewhere highlighting those cases that have been identified in that report. But to be fair to the minister, he also outlined other reasons as to why it is beneficial for the system that you would have a flat fee as distinct from
what I want to have is an efficient court system where people obviously have access to justice and where victims and society can be sure that the courts are dealing with things quickly as possible. The minister says that's his stated objective as well, but what he has done, and through his actions and through his refusal to properly engage, is actually make the situation worse. If you deal with just the adjournments that we've had since this most recent dispute has happened, it means that we're going to have an even longer backlog.
Do you share James' confidence that nobody will look to fast-track cases?
Well, if you take the logic of the minister, because the minister has described the actions of solicitors as being unethical in continuously securing adjournment. So if you're suggesting that there's a group of unethical solicitors, then absolutely the corollary would suggest that under the minister's new model, that there will be people who will be denied the full right to access, because there will be a temptation, let's put it that way, on solicitors not to seek additional reports or evaluations that might otherwise be necessary, but would result in perhaps multiple adjournments.
All right, let's change tack, because in further delays in justice, addressing the Oireachtas Justice Committee today, the mother of the late Shane O'Farrell criticised the pace of bail law reforms. O'Farrell was killed in a hit-and-run incident in 2011 by a man in breach of bail conditions at the time, and who had also held 42 previous convictions. A recommendation made that the sharing of information between court services and Gardaí should be improved is yet to be implemented. Niamh McCormick, what is the take of the Irish Penal Reform Trust on our bail laws? Do they need to be changed? Do they need to be updated? Do they need to be reformed?
IPRT's position, and I think was the position of all of the witnesses at the committee today, is Irish bail laws aren't necessarily the issue. The issue is the enforcement and the application of those bail laws around the country being inconsistent. And so, you know, what happened with Shane O'Farrell and what happened in that case meant that the person who had hit him with a car was out on bail, even though applying the law correctly, he should not have been. And what IPRT has seen in our research mirrors that, which is an unequal application of the law across the country, but also across different demographics.
Do you know why that is?
Well, there's a couple of reasons. One of the reasons is that at the district court level, you have Garda court presenters who present for the prosecution. Those Garda court presenters are not legal professionals. And so, you know, with all of the best intentions, if they're going into a courtroom making legal arguments, if they're not legally trained, there can be flaws in those arguments. The judges can only deal with what's brought to them. So if, let's say you take an example of a flawed argument being brought to a judge, the judge makes the decision based on the information that they have, and then that can feed into the system of simply either getting bail, shouldn't have gotten bail, or we're still, you know, being put into prison when they should not be in prison. And the research that we have and what we're really concerned about when it comes to bail in Ireland is the rates of mentally ill people being placed and being remanded into custody and people who are homeless.
So you're saying be very cautious about what you wish for in terms of changing the bail laws, that be careful about who you put in prison who hasn't been convicted.
Yeah, well, I think it's important to acknowledge that we have a presumption and a right to bail in Ireland and start from that point. And if somebody is not a good candidate for bail, instead of putting them straight in prison, are there other alternatives? And there are alternatives that are available to courts. But when it comes to somebody who's homeless, when it comes to somebody who's in need of serious psychiatric treatment, judges are limited in terms of what they can do.
You know, there will be people watching tonight, Niamh, who'll say, yeah, that's all very well. That's, you know, nice and liberal, but we need to put people behind bars where they belong. What would you say to that?
I would draw their attention to the case of Mr. Ivan Rosny, and his death in custody report was published only a couple of months ago, who was arrested outside of his home while having an acute psychotic episode. He was brought by the Gardaí to the hospital where he was refused admission. He ended up going into remand custody and died in remand custody in active psychosis while being restrained without the treatment that he needed in a completely inappropriate environment. And those are the kind of cases that IPRT are seeing, and that's what we're seeing in the remand system.
Matt Carty.
So can I just make a point on, I know the O'Farrell family personally, and Jim and Lucia are just amazing people, and Lucia herself is a force of nature. All of the failures in Shane's case, the litany of catastrophic failings that resulted in the man who killed Shane being at liberty when he should have been imprisoned multiple times before that, were exposed not by any statutory body or any investigation, but by Lucia and her own tenacity. And then, therefore, when she comes before the Justice Committee and sets out failings that need to be addressed, then we have to take it seriously. And unfortunately,
Lee's point was, though, that it's actually there was failings. It's not the bail laws that was the problem; it's the implementation.
Oh, absolutely. And Lucia O'Farrell was the first to say that the bail laws, in respect of were not so. Judges weren't being informed.
James, very quick word from you on this issue.
Yeah, well, look, I also want to acknowledge Lucia and Shane O'Farrell, and I've met with Lucia on a number of occasions. And I take Matt's point as well. I mean, ultimately, you know, we've heard a lot of criticism of the minister a moment ago. To be fair to the Minister for Justice, he was the minister who got a state apology delivered for the O'Farrell family, and as a result of that, there was a report done into the bail system by Lorcan Staines, and there's two key recommendations that came up at the committee today that I sat on that I do think need to be examined further and haven't been properly done.
The minister's refusing
and one of them, well, let me just say what they are first.
Very briefly.
One of them is that instead of the Gardaí carrying out prosecutions in minor offence cases, that lawyers should be carrying out those prosecutions. That was one of the issues that arose in the O'Farrell case, or at least a corollary of it. And the second one is a more straightforward one. It's perhaps not very sexy, but it's the ICT structure between how the court system talks to the pulse system within An Garda Síochána.
Okay,
and those
makes
two
sense.
changes could actually make a significant difference as to how the bail operates in this country.
Okay, we do have to leave there. Thank you to Niamh McCormick. By the way, some breaking